body to make representations to you. Obviously, when you did that, there's no criticism against the Commission. You didn't realize that there wouldn't be that there would be an objection, but there is an objection, and the time period that passed between receiving the application and the directive was barely a day, and there was simply not sufficient time to indicate to you before your directive was issued what the position is. So in the interest of fairness and in the interest of your hearing from the party affected by the ruling, we obviously submit to you that you can revisit this, and you should. And with that, if I can then just briefly set out the basis of the objection.
Yes.
Thank you, Chair. Chair, the basis of the objection basically is that it's completely ill-conceived in terms of the regulation, applicable regulation 8.3 as read with the rule. And if I can obviously just refresh you, you're very familiar with these and you'll be more familiar with me. Whilst Regulation 8.3 provides any witness appearing before the Commission may be cross-examined by a person only if the chairperson permits such cross-examination, should he or she deem it necessary and in the best interests of the functions of the Commission. That obviously has to read with the rules that are enacted under the regulations, and the pertinent rules are Rule 3. And whilst 3.1 and 3.2 set the general regime, and that is essentially that save where you direct to the contrary in relation to any specific witness, overall responsibility to present evidence is on the evidence leaders, and the evidence leaders are the persons who put questions to witnesses. So we have been given the opportunity to lead Mr. Ngcuka, but that doesn't dispense with the fact that if there's anything that requires clarity, it is the duty of the evidence leaders to put those questions that will clarify that. But we then get to the pertinent part of the rules, and we submit this application is made completely outside of the rules, and obviously you didn't have the benefit of being addressed, but your ruling would also be ultra vires the provisions of the rules. So Rule 3.3 provides if the Commission's evidence leader intends to present to the Commission a witness, and this is very important, whose evidence implicates or may implicate another person, it must, through the Secretary of the Commission, notify the person, the implicated person, in writing within a reasonable time, and it sets out a number of things. But to pause for a moment, the opportunity to apply for cross-examination, and obviously the ultimate decision is only in your discretion, is only in relation to a witness who implicates a person. And in this instance, the application is made on behalf of the Kalata Group. Mr. Ngcuka's statement does not implicate anybody, let alone the Kalata Group. The Kalata Group are not implicated persons within 3.3. So it was not competent for the application for cross-examination to be brought. The threshold requirement, call it a threshold requirement, call it a jurisdictional fact to the application, if you want. And as lawyers, we often talk in our own lingo, but the locus standi to apply to cross-examine is only given to implicated persons. So the Kalata Group as a group has no locus standi, but moreover, the threshold requirement and the jurisdictional fact that they've got to show have not been complied with. So 3.3 then sets out a number of things that the evidence leader informs the implicated person. Now, it's also important to know the initial filter, if you want, is that performed by the evidence leaders. They obviously make the determination if a person is an implicated person, and if that determination isn't made, that's a further reason for the application to be refused. So under the rules, you'll then see that what the evidence leaders tell the implicated person, they tell that person that he or she may be implicated, in what way he or she is implicated, when the witness will give evidence, that there's the opportunity to attend, and then 3.3.6, that if he or she wishes to give evidence himself or herself, or sub 2, to call any witness to give evidence on his or her behalf, or to cross-examine the witness, he or she must apply within 2 weeks from the date of notice, apply in writing to the Commission for leave to do so. We'll deal with the condemnation application shortly, and you'll read in the condemnation application, the Kalata group say that they didn't have, the statement was only provided, I think, on the 24th of February. They couldn't comply with the 2-week period, but we'll get to that issue in due course. Their problems are far greater than just the timing and the condemnation issue. Then 3.4, an application in terms of Rule 3.3 above must be submitted in writing to the Secretary of the Commission within 14 days from the date of the 3.3 notice, and the requirements then become very important. The application must be accompanied by a statement from the implicated person responding to the witness statement insofar as it implicates him or her. You'll see the application here is brought by the attorney. There is no statement from any implicated person, and that's obviously because there is no implicated person involved. But the rule requires that there be a statement by such a person. The statement must make it clear what parts of the witness statement are disputed or denied and the grounds upon which those grounds are disputed. Now, the affidavit is that of the attorney. There's no statement from any implicated person. The attorney's affidavit tries to suggest the paragraphs in relation to which cross-examination should be allowed, but none of that is compliance with 3.4. 3.5 then provides, if an implicated person believes the Commissioner's evidence leader did not give him or her notice referred to in Rule 3.3 within a reasonable time before the witness could or was to give evidence, and that may be prejudicial to him, he or she may apply to the Commission for such an order that he or she will ensure that he is not seriously prejudiced. Then we get to your powers, Chair, and that of the other commissioners. And it's not simply to allow cross-examination, because there are 3 remedies allowed if there's a proper application, and obviously we submit there isn't a proper application. The threshold requirements are not met. But assuming they were, in deciding an application, and I'm at 3.6 of the rules, in deciding an application contemplated in Rule 3.3.6, the chairperson may, in her discretion and on such terms and conditions as she may deem appropriate, grant leave to an implicated person, and here are the options: to give evidence, to call a witness to give evidence on his or her behalf, or to cross-examine the witness implicating him or her. All that you have in a defective application before you is a remedy that asks for cross-examination. You're not told why any prejudice that there may be, and we submit there's none, can't be cured by the Kalata group calling a witness to give evidence, or to give, in this case, the implicated persons, if there were such, and we keep saying there aren't any implicated by Advocate Ngcuka, you've got to be addressed as to which of those 3 alternative remedies you should direct. So the threshold requirement is not met. You're not told in the application why the other remedies are not sufficient. And whilst, yes, it's worth also recapping 3.7. In accordance with Regulation A3, there is no right to cross-examine a witness before the Commission, but the chairperson may permit cross-examination should she deem it necessary and in the best interest of the work of the Commission to do so. Now, Chair, this hearing is obviously one that's to get to the truth of matters, but it is not a curtain raiser, and it is not a trial within the trial for any claim or application that may come from the Kalata group in due course. So when you bear this in mind and you go to the actual application, you'll find that the application doesn't bring itself within the rules. The fundamental requirement that it's got to be made on behalf of an implicated person, and that is a jurisdictional fact, a threshold requirement which is compulsory. There's no issue of discretion involved in there. It's simply not made out in the application to cross-examine. All that you're told is in a covering letter that accompanied the application from Weber Wenzel on the 26th of February 2026. You're told we act on behalf of the Kalata Group and 24 other families. We refer to the timetable circulated, and then paragraph 3. So they invoke the rule. Rule 3.4 provides that the application must be accompanied by a statement from the implicated person responding to the witness statement insofar as it implicates him or her. And paragraph 4, we attach here to our statement, the attorney's statement, not the implicated persons, setting out those averments that we dispute in Advocate Ngcuka's statement. And then when you look at this, there are certain paragraphs that they wish to cross-examine on. As I've submitted to you when I was taking you through the rules, no suggestion as to why any other remedy can't be invoked. And for example, in relation to some of the issues, I put this up just as an example. There's no reason why, I'm not sure if Mr. Ackerman has given evidence here or not, but it's something that, all of this can be, there's a witness that's coming. If there's anything that requires clarity, I use this as an example from Mr. Ackerman. This can be put to Mr. Ackerman. It goes to the point that there are 3 different remedies provided in the rules, and you will decide, a case has got to be made out to persuade you which one to invoke. Chair, I want to say at the outset, it is not that there is anything that we wish to shield Advocate Ngcuka from, but the issue is a critical one of vires and powers of the Commission to direct a cross-examination in circumstances where there is no meeting of the jurisdictional requirements in the rule. And we all know that in commissions the right of cross-examination is a very limited one. It's not it's not even a automatic right. It is a privilege that you and the commissioners give a party, but to qualify for that privilege, those requirements have to be met. The other reason why it's critical is that this issue is going to arise in relation to other witnesses who we represent. Obviously, we'll deal with the application at the relevant time, but as a point of principle, this Commission has to enforce its rules, and it has to require that parties that bring applications comply with the rules and make applications that are recognized and permitted under the rules. So we submit that, having had the benefit of hearing from us now, you should withdraw the direction that you were given and not permit cross-examination. If you can bear with me for a moment to just consult with my team. Those are our submissions.
Thank
Chair.
you, Mr.
Thank you for the opportunity.
Thank you. Mr. Vani.
As the Commission pleases. Chair, my learned friend, Mr. Banda, has not put up anything of substance. Oh, sorry, Mr. Bana.
Yes.
Apologies, Chairperson, and apologies to Mr. Bana. He hasn't put up any substance to warrant disturbing the Chair's ruling. We would suggest that the opposition is without merit. This Commission is entitled under Regulation 8.3, which my learned friend has read out, so I won't do so as well, read with Rule 3.7 to grant permission to cross-examine when the Commission believes it's necessary in the best interests of the work of the Commission to do so.
Why was there reliance by you, Mr. Vani, on why did you invoke Rule 3.4 in your application?
Well, in fact,
was that inadvertent? Was that meant to mean Rule 3.7?
Chairperson, it was likely inadvertent. We were, of course, looking for a procedure, and the only procedure in terms of timeframes and what had to be put up was sitting in Rule 3.4. And also the evidence leaders indicated to us that we would have to apply for condonation because of Rule 3.4. Our view, Chair, is that there's no procedure, no timeframes attaching to Rule 3.7 and Rule 8.3. But out of abundance of caution, we applied for condonation nonetheless. and we put up a statement, even though 3.7 and Regulation 8.3 don't require it.
Yes, and that's my confusion, because your application seems to be centered around Rule 3.7, the Rule 0.34, when you have made an application under Regulation 8.3, which says any person may be cross-examined, not necessarily an implicated person.
Yes, indeed, and for good reason, Chairperson. And I'll just give an example from another commission. The Marikana Commission of Inquiry, which had largely similar rules to this commission, there George Bezos represented certain families. They, of course, were not implicated persons. But Mr. Bezos, as well as representatives of other families and surviving workers, were permitted extensive opportunity to cross-examine.
Yes, but without reliance on Rule 3.4, I'm sure.
Yes, yes, indeed. Chairperson, to the extent that we refer to 3.4, that is inadvertent, and we simply put it up for purposes of explaining why we were putting up a statement and applying for condemnation, even though 3.7 and 8.3 don't require that procedure. Chairperson, we in fact had no intention of cross-examining this witness on the basis of what was before this commission prior to the 24th of February, that was last week. It was only when we were given his statement that we realized we may have questions that move beyond follow-up or clarification, and that there might be objections to those questions. So out of an abundance of caution, we then applied, I think within 48 hours of receiving that statement, to cross-examine this particular witness. And realistically, of course, decisions can't be made until one has seen the statement in question. I understand this chairperson has already ruled that parties may even apply for cross-examination post viva voce evidence, and I think that permission reinforces the approach that the Collator Group has taken. Let me just see if there's anything else. Yes, Chairperson, in conclusion, it would really disrupt the fact-finding function of this commission if, in fact, my learned friend is correct that the jurisdictional requirement is confined exclusively to Rule 3.4. That simply can't be the case. That would mean only implicated persons would have the opportunity of cross-examining, and interested parties would be excluded altogether, and that couldn't have been the intention behind the regulation read with the rules. Those are our submissions, Chairperson.
Thank you, Mr.
Thank you, Chair.
Stefan.
With your leave, if I may reply.
Shall I give, before you, Mr.
Yes.
Bana, may I give Mr. Siminya an opportunity to respond?
Chairperson and Commissioners, I submit that the concession by Mr. Vani that the invocation of Rule 3 was inadvertent, he says, and we agree with that. And as regards the applicability of cross-examination, clearly that is in the regulations, and Chair, you've just read the Regulation 8.3. In terms of that, the discretion is that of the chairperson with, as they use the word, jurisdictional fact, that you deem it necessary or it is in the interests of the work of the commission. When those two are met, then the right to cross-examination would arise. The difficulty in this instance is that the application the statement was received pretty late for this exercise, and if the chair is minded that cross-examination may prove to be necessary and in the best interest of the work of the commission, then that would arise. We would submit that the only outstanding element to that is the when, if the chair is so minded. It would seem to us as evidence leaders that a date other than today, given the proximity to this application as well as the ruling if the previous one is varied, Mr. Ngcuka and team may very well be entitled to a reasonable period to prepare for such cross-examination if it arises. Those are the submissions of the
Thank you.
evidence leader.
Just, Mr. Siminya, on what you are advancing, would the Commission not fetter its powers unduly and irregularly by, say, not following what the chair has indicated in the first place? Because what Mr. Vani advanced in the first place was an aberration, more an aberration than maybe, yeah, was it not an aberration? And if it's an aberration, that can be ignored.
Well, I would submit, Chair, that aberration or inadvertence may very well be interchangeable in the context. But what we're submitting, though, is that at least the applicability of cross-examination under 8.3 of the regulation is present. So it would still be within the powers of the Commission, and that particularly of the Chair, if she is so minded to conclude that the interest of the work of the Commission is extant.
Yes.
Those would be my response,
Yes,
Commissioner.
Thank you, Chair.
Thank you, Mr. Pana.
Thank you, Chair. The first point to make is this. There is no independent, self-standing right to cross-examine under 3.7, divorced from the rest of Rule 3. So when our learned friend, Mr. Vani, says to you it was inadvertent, firstly, it's a submission from the bar. It was not inadvertent. There was every intention to rely on it, and we'll show you why. The reliance was made by an attorney, an experienced attorney, and made under oath. But you don't need to get entangled on the inadvertence issue, although I will address you on that. The primary submission is that 3.7 is not a self-standing independent right which you can divorce from the remainder of what is in Rule 3 dealing with cross-examination. And that includes 3.3, 3.4, the remedies you have that I read to you. I think that was under 3.6. So when you follow the regime of the rule, and there's a very good reason for this, and that is because there's a very limited role for cross-examination in these proceedings. The evidence leaders, and they have an experienced and substantial team, are the persons firstly tasked to check if there are discrepancies in a witness statement with other documents or other witness statements or other evidence that they have. They work through that, they filter it, they decide what questions are going to be put and which witnesses are to be led.
But Mr. Pana, in this case, you have applied to lead evidence of Mr. Ngcuka.
Yes.
So the evidence leaders have very little role to play with regard to the leading of his evidence.
Yes, but that doesn't abdicate their responsibility completely.
Yes,
to
that is so, but that should also not be lost sight of.
Yes, we take the point, but the evidence leaders can put any questions for clarification that they want. They can examine Mr. Ngcuka, and that is primarily their responsibility as evidence leaders. But to come back to the point, the entire premise of the argument that we heard from Mr. Varney is that there's some self-standing rule or right under 3.7 to cross-examine where you don't have to follow what precedes it, and that is completely incorrect as a legal premise. There is no self-standing right. There isn't a 3.7 right to cross-examine and a 3.3 and a 3.4 right. I call it a right for the moment, or right to make application to cross-examine. So once that is appreciated, you are bound by your rules, Chair, and you are bound to give effect to all of 3, not just 3.7.
Mr. Barner,
Yes.
what do you make of the fact that the heading to Rule 3 deals ostensibly with 2 types of persons who give evidence to the Commission? Witnesses presented by the Commission's evidence leader and implicated persons and their evidence. Is the focus of Rule 3 as narrow as you suggest it is?
Firstly, we all know the difficulty of relying on headings for interpretation, so keep that as a caution whether one can rely on headings. But having said that, there is no tension between that. The primary responsibility, whether it's an implicated person or a witness presented by the Commission, the primary responsibility to lead evidence and to test that remains on the evidence leaders. What then is provided for, there is an indulgence, if I can call it that, where it is an implicated person, the indulgence to apply for cross-examination by parties who are not the evidence leaders is then provided in the rules. So the short answer is there is no tension between those 2 provisions.
Thank you.
But let's deal then with the issue of this inadvertence, because you've been told this from the bar. It's just a convenient out to try and get over the difficulty provided by the rest of the rule. Firstly, in the application letter itself, as I read to you, the letter that accompanied the application, Weber Wenzel's letter of 26 February, the partner, Ms. Asmita Thakur, relies pertinently on Rule 3.4. Then, more importantly, when you get to the condemnation application, so if it was inadvertence, there's one mistake and it must be explained under oath. It's akin to a withdrawal of an admission. You bring an application under a particular rule. You can't just stand up and say, well, I inadvertently brought this under the wrong rule. But my submission to you is that it is not inadvertence. There was a specific reliance on 3.4, and correctly so, because they realized they had to follow the regime, the entire regime under 3 that deals with cross-examination, starting at 3.3. So when you read the condemnation application, and if I can just look at the main application, I've made the points to you. This main application doesn't meet the threshold requirement. It was incumbent on the party seeking the cross-examination to make out a proper case and bring itself within the rules. They tell you they're bringing it under 3.4, and then you read the condemnation application, and under oath, Ms. Thakur says a few things to you which are relevant to your dismissing this argument that it was inadvertent under Rule 3.4. Again, in the condemnation application, 27 February, the covering letter again deals with non-compliance with 3.4, and I want to make the point, I'm not for the moment addressing the time issue on the condemnation, but the reliance on the rule. You then get to the affidavit itself, and you see in paragraph 3, this application was made in terms of Regulation A3, read to the extent necessary with 3.4 of the Commission's rules. There is no reliance in this affidavit or anywhere on Rule 3.7. One can't create a basis for an application where none was put forward. So you see that pertinently in paragraph 3. Again, in paragraph 6, there's the reliance on Rule 3.4. So you now have 4 instances of reliance on 3.4. There's got to be a proper explanation if you're now told this was inadvertent, not just a statement from the bar where the shoe pinches. You have no such explanation, but we also remind you of our primary submission. You can't make an isolated, self-standing application under 3.7. That is not what's envisaged. So you can never get away from 3.4. You can't say this is a 3.7 application, so I don't have to meet the other requirements under 3. That is the
Yes.
primary submission.
But it is your own submission, Mr. Bana, that Mr. Ngcuka is not an implicated person.
It's not a...
That the Galata group are not an implicated
Yes.
person.
Yes, and that is because it goes to the point that you can't come and willy-nilly cross-examine people. No, the point is a different one. It's not that Mr. Ngcuka is not an implicated person. It's that Mr. Ngcuka doesn't implicate anybody.
Yes.
So there's nobody that can invoke, in relation to Mr. Ngcuka's evidence, there's nobody that can invoke 3.3, and that's why they don't bring themselves within 3.3 and the regime in 3.3, 3.4, etc.
Yes.
Because he hasn't implicated anybody. And then, of course, we had anecdotal evidence about the rules in another commission, whether that was argued in the other commission, what their rules were, are not before this commission and are irrelevant to this commission. So what happened there and what Mr. Bezos was allowed to do or not do is entirely irrelevant. If I may then just address the point raised by the Commissioner on the fettering of the discretion. There is no fettering of a discretion, because what is required is that to obtain the right to cross-examine, you must bring yourself within the rule. If you bring yourself within the rule, the Commission has to apply its mind as to which of those three alternatives it's going to allow, the 3.6 alternatives, and there is simply no issue that by allowing, by not following the rules, you would be fettering your discretion. You are obliged to follow those rules. Those are your rules. They're the rules of this commission. One cannot selectively apply them or simply suggest, well, we're going to depart from them because that would be a fettering of our discretion. The rules provide the circumstances under which an application can be brought. There's a very good rationale for those circumstances, and that is primarily the issue of leading evidence and testing evidence is on the commission leaders. And if there's going to be a departure, you've got to find a provision in the rule which permits of that departure. That is not there, but more importantly, the Weber-Wenzel application doesn't ask you or doesn't invoke a departure from the rules. They pertinently invoke the rules. So what they've done here is they've invoked the rule, but they've not brought themselves within the very rule under which the application is made. And this convenience of simply submitting from the bar that it was inadvertent is not to be accepted. Those are our
Yes.
submissions.
Thank you, Mr. Bana.
Thank you, Chair.
We'll take a short adjournment before we come with a ruling. This is my ruling. I issued a directive in this matter on the basis that it was made under Regulation 8.3, read with Regulation 7.3, which reads as follows: any witness appearing before the commission may be any witness, whether implicated or not, may be cross-examined by a person only if the chairperson permits such cross-examination should she or he deem it necessary in the best interest of the functions of the commission. It is my considered view, having heard Mr. Bana on behalf of Advocate Ngcuka in his objection, that my ruling cannot, my directive cannot be varied, but I direct that it be varied to the extent that the direction gave Mr. Ngcuka the right to be cross-examined today. I therefore direct that cross-examination of Mr. Ngcuka be on a date to be determined by this commission.
As the commission pleases.
As the commission pleases.
Thank you, Chair. Is it envisaged that the evidence in chief of Mr. Ngcuka is given today, or do we
Yes,
adjourn him
it is
completely?
envisaged that we will proceed with the evidence in chief of Mr. Ngcuka.
Thank you. Chair, may we also, while you're considering practical issues, raise this? We'd ask then that in the light of your ruling, that you amplify your ruling, that the examination of Mr. Ngcuka is going to be in relation to those aspects identified in his statement.
Yes.
Otherwise, it's of course a blind
Yes.
free-for-all.
Yes.
So if we can
Yes.
confirm that. And also what would assist is we've been given 2 lever arch files by Weber Wenzel at 10 o'clock this morning of documents that may be put to Mr. Ngcuka. Now, we're told that they're all somewhere in the applications, but of course it doesn't help to trawl through 2 lever arch files. If you can direct that they simply give us a list of the page numbers of the documents that are going to be put. It will also shorten the time spent with Mr. Ngcuka and how long we'll need to come back on the adjourned day for the cross-examination.
Yes, Mr. Vani, are you able to assist Mr. Bana in regard to that?
Yes, we can do that, Chairperson.
Yes, now that we have sufficient time to plan for that.
As the commission pleases.
Yes. And may I just get an indication from the evidence leader, what time span are we looking at in terms of inviting Advocate Ngcuka to come back for his cross-examination?
Chair would think 14 days would be a reasonable period for cross-examination to happen, but we're not inflexible about that.
Yes. Mr. Bana?
Chair, we have no difficulty with the time period. Obviously, it will be at a time that can accommodate us
Yes.
reasonably.
So 2 weeks would be sufficient time for you
Yes,
to
subject,
prepare Mr. Ngcuka for his cross-examination?
indeed, subject to diaries. And if we can also just ask then that Mr. Vani's a list of documents that are going to be put, if those can be given to us within the next, he obviously came today ready and knows the list, if it can be given to us within 2 days.
I direct that the list to be provided or to be furnished by Weber Wenzel be given to the Tabata attorneys by the 4th of March, 2026.
We shall do so, Chairperson.
Thank you. Mr. Banai, your witness.
Thank you, Chair. If I can have half a minute just to get organized.
Mr. Banai, would it be convenient for us to adjourn now for tea in order to properly prepare Mr. Ngcuka for his evidence in chief before we proceed?
Chair, we're in your hands. We can proceed now, or we can take the tea adjournment.
I think it will be convenient to take a tea adjournment and reconvene rather at 11:05.
As it pleases.
We'll take a short adjournment. statement. Mr. Bana?
Thank you, Chair. Good morning, Mr. Ngcuka. How are you today?
I'm fine, and thank you very much.
Good, thank you. Can I call you Advocate Ngcuka?
No, call me Bulelani.
Shall we proceed to take an oath before you proceed,
Yes.
Mr. Bana?
Thank you, Chair.
Advocate Ngcuka, are you going to take an oath or an affirmation? Please state your full, an oath. An oath.
Yes, an oath.
Please state your full names for the record.
My name is Bulelani Ngcuka.
Do you swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you. Mr. Bana, your witness.
Thank you very much, Chair. Advocate Ngcuka, you made a statement dated, it simply says February 2026, but I believe it was furnished on the 24th of
That's
February
correct.
2026. You have that statement before you.
That's correct.
What I propose to do is just to give you a chance to go very briefly through the initial portions of the statement, and when we get to the sections that deal with the allegations of attempts to influence or pressure the NPA from paragraph 35, I will then put particular paragraphs to you. So firstly, do you confirm the statement that you made on 24th February 2026? Do you confirm it under oath?
Yes, I do.
Thank you. Can you then, very briefly, because a lot of it is set out in the statement, and I might add, very impressively so, just tell the Commission, firstly, about your personal background?
Yes. Well, I state there that I was born in Middledrift in the Eastern Cape, and that I studied at the University of Fort Hare, where I obtained my BProc degree. And whilst at the university, in fact, in 1997, when Steve Biko died in police custody, 1977, yes, we organized a memorial service. Sorry, Chair.
Thank you, Advocate
I
Ngcuka.
state that we, as students, we organized a memorial service to commemorate the death of Steve Biko in police custody. The rector of the university at the time refused us to use the Great Hall, which forced us to organize the memorial service, to have the memorial service at the sports stadium. We were then arrested and sent to Kwanongong, which is Fort Glamorgan in East London. We spent about a week there, and then we were charged with contravention of the Writers' Assemblies Act and sentenced initially to 30 rand or 30 days imprisonment, which was later on appeal converted to a caution and discharge. Completed my degree, worked for a short while at Mtanzane as a prosecutor, and then I was offered articles of clerkship by the late Griffiths Mxenge. I served my articles with him, and at that time, the practice mainly focused on political trials and human rights cases. Some of the cases that we handled were those of Joseph Mdluli, who also was killed by the police. And then the Biko family, who represent the Biko family, who represented the Mohapi family, who also was killed by the police in custody. So we handled a number of trials, including the PAC trial in Bethel, that of Zef Ntuping. GM was killed by the police on the 19th of November. I accompanied Mrs. Mxenge to the mortuary. That's where we found GM. The stab wounds in his body were just too much to bear. I was then helped the family to organize his funeral. I was detained on the 30th of November, 1981, spent 8 months in solitary confinement. And later I was then asked to give evidence against my colleagues, Patrick Ndaweko and 2 others who were charged with high treason. I refused to testify. I was sentenced to 3 years imprisonment, which I served in various prisons, including Lukop, Victor Versteeg, Elderstrom in Caledon, and so forth. The day before 2 days before I was released in 1985, I was visited by Mrs. Mxenge, who was then running the firm, together with my wife. We spent a day together. I was still in prison. The following day, I was informed by the head of the prison that the woman who had visited me had died. I later learned that it was Mrs. Mxenge who had died. I was released on the 3rd of August, and from prison I was taken straight to the mortuary to visit Mrs. Mxenge. Later I left. I went to Switzerland. I joined the International Labour Office, worked there in the Equality of Rights branch called Equality, participated in the anti-apartheid movement. Then I studied, I forgot something. When I was in prison, I also completed my LLB with UNISA. And when I was in Geneva, I then did my master's at the University of Webster, focusing on international relations. Again, when I was in prison, I forgot that. The Law Society made an application to have me struck off roll. I resisted that, and successfully too. And so I came back into the country after the stint in Geneva. I came back and then settled in Cape Town, joined the firm of NJ Yekiso and Associates, back into doing political trials. I was again detained in 1988 because as the UDF, we then decided to organize a celebration of Mr. Mandela's 70th birthday. You might recall that that year, the anti-apartheid movement in the UK had organized a big concert at Wembley Stadium. We decided to do the same thing. I was then detained because of the chairman of the Mandela Birthday Committee. I was detained under the state of emergency, spent a month or so in prison, was released, went back to practice. In 1989, I was again detained because at that time we organized the Defiance Campaign, and I was one of the leaders in the Western Cape of that Defiance Campaign. Detained again, spent another 2 months in prison. Upon my release, I was served with a banning order confining me to Newlands Magisterial District, which included Guguletu. No visits between 6 in the evening and 6 in the morning. Could not be visited by more than 2 people at a time. And that was it. And then 1990, with the unbanning of the ANC, I was invited to serve on the ANC Constitutional Committee. We then drafted the ANC's position in the negotiations, participated in the negotiations, and then went to Parliament. I was the chief whip of the majority party in the Senate. I served in the various committees. I chaired the joint committee that appointed the Human Rights Commission, the joint committee that appointed the Public Protector, served on the Rules Committee, served on the Judicial Services Commission. With the new constitution, I also served on the Constitutional Assembly, served on the Constitutional Committee of the Constitutional Assembly, led the discussions on the judiciary, And so, with the adoption of the new constitution, I was appointed the deputy chair of the National Council of Provinces, and then a year later, was appointed the National Director of Public Prosecutions.
Yes, if you can just pause there for a moment. You appointed on the 1st of August 1998, and when did your term of office end?
I assumed office on the 1st of August, and I left office on the 31st of August, 2004.
Now, you wanted to include some of this background in the statement, and can you just explain to the Commission the reason why you wanted to put this before the Commission and how this influenced your attitude to cases that had come before the TRC?
Okay. Thank you. No, I thought it's important that the Commission understands who the person who assumed this office and what my background is and why I treated these cases, the TRC cases, in the manner in which I did. Two things that I didn't mention that I think are important. Joseph Mkhuli, I've mentioned, was killed by the police. 4 of them were later charged. And one of those was a guy called Andy Taylor. And this was the guy who investigated us when we were detained. They were charged, subsequently charged, and their case was dismissed at the end of the state case. It was badly handled. Later, you might know, there was a case of General Magnus Malan. They were charged just before 1994. They themselves, again, that case was dismissed at the end of the state case. It was badly handled. And so I took the decision that these cases, I didn't want that to happen to them. And so that's why I had these cases handled in my office.
So what was your personal attitude or standing as to the vigor with which cases that emanated from matters revealed at the TRC should be prosecuted?
No, I mean, I really wanted those cases to be prosecuted, seriously so. I wanted the people who had committed those atrocities to be charged and sentenced. And that's a conviction that I had.
Yes. Just to pick up on a portion of your statement, and in paragraph 15 of your statement, you were not served a notice to appear before this commission or subpoenaed to come before the commission. You have come before this commission voluntarily, sir, is that correct?
That's correct.
And why do you do so?
Because I thought that it would assist the commission if I gave the background to what happened and what I did, because these cases were referred to my office at the time when I was the national director. And therefore, I thought it is important that I have to account about what I did when I received these cases. And so to give the commission the background to the work that I initiated.
And you're here to give frank evidence to assist the commission in its work, is that correct?
That's correct.
Can I pick up at paragraph 18 of your statement, and if you can just elaborate on that? Basically, you deal with the position you found when you started at the NDPP, and in particular, we're interested in the position as to resources that were there and available.
Yes. Well, when I reported for work on the 1st of August, I went to the Department of Justice and I met with the Director General, who told me that they've budgeted 6 million for my office. And that money was sufficient to pay for my salary and a few people that will employ, that it will take me probably another 6 months or so to set up the office. I had no office, nothing. So I went around looking for offices. And when I found the offices, there was no furniture, nothing, absolutely nothing. And there was a great expectation from government and from people that my office will solve some of the problems that were prevailing in the country at the time. And so I came into office literally with nothing. I was fortunate in that my brother-in-law was working at the Reserve Bank. And the Reserve Bank had this habit of changing their furniture every 5 years. So I inherited the furniture from the Reserve Bank. That's how I started my office. And I was then forced to rely on other government agencies for the work that I had to do. So I had to foster relations with the Department of Justice, with the police, with the intelligence, and all other government departments, and work very closely with them. And those are the people who helped me to set up the office.
Generally, can you talk about the level of availability of resources in your office at the time, and perhaps take us through to the end of your tenure in 2004? What limitations were there on resources? How readily were resources available? How did you have to prioritize decisions?
Oh yes, I mean, we really had a challenge. When I was in government, when we came into office in 1994, it's a matter of public record that we inherited a country that was bankrupt, had no money. And so I knew that. And so the resources that were available to us to set up these structures were very, very limited. And hence we relied a great extent on cooperation with the other departments, sharing the resources, which were very, very limited. There was a problem.
How did that change, if at all, by the time you left office in 2004?
No. It had not changed, but it had improved.
Considerably? Was there still a tension fighting for resources to investigate different types of crime?
There were serious tensions. We used to fight a great deal with Treasury. Because those guys, they will tell you that they are trained to say no whenever you go and ask for money. So, indeed, that was a problem.
And did that place a constraint on how resources were allocated? Choices had to be made, and did that scenario persist by the time you left in 2004? I understand it might have gotten a bit better because you fought for resources and you did a whole lot of things, but was there ever a position where there were ample resources available to do whatever was necessary to be done in your office?
No, we didn't. We didn't have enough resources, even up to the time I left. I mean, I make the point, for example, that when I established the Specialized Commercial Crimes Unit, we had a big problem. Commercial cases were not being prosecuted because they did not have experienced investigators to do that. And we had files that were collecting dust here in the Johannesburg office. And so I had to work with the Business Against Crime to establish the courts. The first court that we set up was in Pretoria. And also had to employ investigators from the private sector. And I had to use the Business Against Crime for us to be able to do that work. So that speaks to the availability of resources.
Yes. In your statement in paragraph 19, you say, I inherited a prosecution service which was characterized by low staff morale, which lacked credibility and legitimacy in the eyes of the majority of society, which viewed the prosecution services as part and parcel of the state's oppressive state machinery. There was also high levels of criminality, particularly in areas such as the Western Cape. In that year, there were 166 pipe bomb incidents and no arrests or prosecutions. In KwaZulu-Natal, there was extreme political violence, and Gauteng experienced a high level of car hijacking. Can you, against that, give the Commission a feel for the different areas of criminality, if I can call it that, which you had to turn your attention to and devote limited resources to?
Yes. We had, excuse me, we had serious problems in the Western Cape. Gangsterism, as well as there was an organization called Pakat, which started off fighting gangsters, but at the end they themselves were the perpetrators of violence in that area. I'll give you one example. There were a number of bombs that were exploding. There's one that exploded in the Hollywood cinema in the waterfront. Again, you also had one of the investigators in that case who was killed, where the magistrate who also was killed by the same people in the Western Cape. And there were no successful arrests or prosecutions. And so I had to start a new unit called the Investigating Directorate on Organized Crime and Corruption, where I had to work with the police and the intelligence people, take those and put them under my wing, working flat out. I started what was then known in South Africa as prosecution-led investigations. Because in the past, they were working separately. The investigators will go on their own, they will investigate a case after a year or two, and then bring the docket to the AG's office. We'll take another 6 months starting the docket and then issue instructions, which delayed matters. So I changed that. I brought all those under one roof, the intelligence, the investigators, analysts, and prosecutors, all working together. And we succeeded in ending that violence in the Western Cape. At the end of the day, when we were done, we had probably more than 100 people who had been arrested and charged and others served life imprisonment. Equally, would experience serious levels of violence in KZN, particularly in an area called Richmond. We had, in a space of 3 weekends, more than 100 people killed. We worked on that. I established another entity in KZN that is focused exactly using the same model, focused on dealing with those. And I appointed a guy called Chris Macadam to lead that investigation. And they did very well. We again were able to succeed, to find those people, prosecute them, and have them sentenced. So we dealt with those issues.
Yes.
Similar things happened here in Gauteng with carjackings. In the past, we had focused just on arresting the people who were behind, who were doing the hijackings. But when we started, we said, no, let's look for the kingpins. Because the guys who are running around taking the cars, they sell them somewhere. There is somebody who's organizing, who orders these things, and we focused on that. And again, I'm happy to say we're very successful with the work that we did.
The picture that emerges is a number of priority areas requiring prosecution, competing areas competing for limited resources.
That's correct.
Is that the environment which you referred to in your statement and which you confirm was to be found at the NPA while you were there?
That's correct.
You then, in your statement, deal with TRC matters, and perhaps you can very briefly take us through that, essentially paragraphs 25 to 34 of your statement.
Yes. I think it's important to note that when I set up the NPA, I inherited the people who were working there. And some of these people are the ones who were prosecuting us when we were waging the struggle. And so I had to deal with these people that I believed, correctly so, that indeed they were part and parcel of the system that was oppressing us. And so I had to work with them. So I was worried. I was worried that I could not have the very same people to prosecute the TRC cases. And so when I received the report from the TRC, the first thing I did was to appoint then Vincent Saldanha, who I knew from Cape Town. I'd worked with him.
Is that Judge Saldanha now?
That Judge Vincent Saldanha now. I knew him very well. And I then appointed somebody else also from the office, who was based in the Johannesburg office, Bring Ferreira. I asked them to do an assessment of these cases. Because I needed to have a record and know which cases were ready for prosecution, which cases needed to be further investigated, what the shortcomings were, and so forth. They did that. And then they gave me a report. Based on their report, we then agreed that we needed to have a specialized unit in my office that will give focus attention on the TRC matters, which is why we then created what we then called the Priority Crimes Unit, and appointed Anton Ackerman to head that.
Yes.
Anton had just finished doing a long case that he was involved with, involving Vota Passon. So I then appointed him to do that.
Yes. Perhaps just before we go further on that, in paragraph 27 of your statement, you say, you firstly talk about the Human Rights Investigative Unit, which we've abbreviated as HRIU, and you then say the HRIU report identified challenges in several high-profile cases. Notwithstanding the rejection of several amnesty applications by the TRC, the available evidence in many cases was not, in the unit's assessment, sufficient to sustain a successful prosecution in a number of these cases. In some cases, offences had prescribed. In others, witness availability or reliability presented insurmountable obstacles. Many additional matters could not be processed to prosecution stage due to the pending amnesty committee applications brought by suspects, further delaying decision-making. You obviously confirm that, but perhaps can you just elaborate on that?
Yes.
briefly?
No, I do confirm that. There were some of the cases, you take, for example, you take the Biko case. In that case, we realized that we did not have sufficient evidence to get a conviction. We knew, we all knew that the police had killed Steve. We knew that. And so to go and take those police to court when we didn't have sufficient evidence, they would have been acquitted. And would have ended up with egg on our faces to go and prosecute a case that you know you're going to lose. The evidence was just not enough for us to do that. So those are some of the challenges.
I presume channeling limited resources to prosecuting those cases which you took a view you would not get a prosecution on.
But I mean, most importantly, counsel, was that you're going to go and take people to court well knowing that you're going to lose. It would have been wrong.
Yes. In paragraph 28, you deal with Mr. Silas Ramaite, and then you say you decided that all TRC cases should be brought to the Special National Projects Unit, SNPU, within the Scorpions, headed by Chris McAdam. Is there anything you wish to elaborate on in that respect?
Yes. Silas informed me that there were these cases that were, these dockets in fact, that were in the Pretoria office. These are old cases. And that nothing was being done about them. Nobody was paying any attention to those cases. And so we then realized that it is possible that in also other DPP's offices throughout the country, there may well be some of these cases that are there and which are not getting the attention they deserve. So it is on that basis that I then issued the directive that all these TRC cases must be centralized and be brought to my office.
And classified as priority crimes, as you state in paragraph 31 of your statement.
Correctly so.
And you say that was to ensure a single, specialized, nationally coordinated approach to prosecutions emerging from the TRC.
Correct.
In paragraph 32, you say, after assessing evidentiary sufficiency, witness availability, legal viability, and the prospects of a constitutionally compliant prosecution, the PCLU identified approximately 21 cases warranting further investigation.
Yes.
You confirm that?
Yes, I confirm that.
And I don't know if it's from those 21 cases, but by the time you left office, I understand at least 6 cases were taken to court, so to speak, of those cases that the office identified warranting further investigation.
That's correct.
In terms of the benchmark and the environment that was at the NPA, in your assessment, was that a good track record or not?
Oh yes, that was good work that had been done. The guys had worked flat out, given the limited resources that they had. I was satisfied with the work that the unit had performed at the time. I was very impressed with the work that they did.
We then get to the section that deals with the allegations of attempts to influence or pressure the NPA to stop investigations or prosecutions during your tenure. And can you deal with paragraph 35 of your statement, please?
There were no attempts during my time. Nobody tried to do anything. I mean, there were no such attempts at the time. But what I can then say, probably we're going to get to it. We were invited into a meeting that was convened by the Director General of the Department of Justice to look into amending the prosecutorial policy insofar as it dealt with the TRC matters. My office was represented then by one of my advisors, Lungisa Josi, and another guy called Gerard Nel. Gerard Nel's responsibility in my office was to prepare legislation that had to go to Parliament. He was specializing, he was drafting legislation. We discovered early on that it is important for us as the NPA, if any legislation is to be passed, that we are consulted and that we contribute to it. And so we created that capacity in my office. So Gerard and Lungisa went to that meeting, and they came back and reported to me what had transpired in the meeting. And their view, which I accepted, was that there's no need for us to participate in that forum, and that there was no need for us to change the prosecutorial guidelines that we had. And that's it.
Yes. In paragraph 35, you also state, I am also not aware of any collusion by any member of the NPA with any such attempt to stop the NPA from investigating or prosecuting TRC cases?
Yeah. Nothing of the sort happened during my tenure.
Mr. Ngcuka,
Yes, sir.
the invitation by the Director General that we have referred to, you don't have a date for that? Were
No.
any minutes taken?
I don't know. You remember, Commissioner, I didn't attend that meeting myself. And so my colleagues had gone to the meeting and they came back and reported to me. And that was it, as far as I'm concerned. The matter ended there. So I was not aware of any minutes or dates. I can't remember the date, but it would have been somewhere in 2003.
Yes.
Thank you, Commissioner. Advocate Ngcuka, in paragraph 36, you say, I have in the above background set out the context and circumstances in which the office of the NPA was established within an evolving prosecutorial environment at a time when South Africa was establishing for the first time a single independent national prosecuting authority. This required significant institutional reform, the development of new systems, policies and standards, and the consolidation of prosecutorial functions previously dispersed across apartheid-era structures.
That is so.
And you go on to say, in 37, the prosecutorial terrain during the early 2000s was new, complex, constantly evolving, necessary to build national capacity, ensure consistency, establish specialized units, restore public confidence and in the prosecuting authority. These institutional priorities required careful allocation of limited resources and personnel.
I confirm that.
Do we understand that the competition for resources was not just across these very high-profile crime areas, but also on an administrative front, that there were huge challenges in terms of resources?
That's correct.
And you say in 38, within this context, the NPA was simultaneously confronted with high-profile resource-intensive matters, including complex commercial crime prosecutions, organized crime syndicates, national security cases, and international law matters arising from South Africa's obligations under the Rome Statute. This reinforces what you said earlier by way of the examples that you gave.
Yes.
I just want to go back to an aspect. In paragraph 35, you said you were not aware of any collusion by any member of the NPA or any attempt to stop an investigation or prosecution. Had there been such an attempt, I'm postulating a hypothetical, had there been such an attempt or an approach made to you, what would your attitude have been and why?
Okay. You know, when you are the national director, you get all sorts of approaches. People come every other day trying to influence you, to persuade you, you do this, can you help me, can you have this case with them, can you do that? You listen and you tell them where to get off. And so, if there had been such an attempt, I would have been able to say, no, no, no. This is not how things work. This is what works. And this is what I will do. End of the day, the decision remains mine and mine alone. And I have been able to say, no, 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 no. I don't go along with this. And I did that successfully throughout. But I was never even approached on this one.
Yes.
To say, can we do this? No. At the time I left, no one had approached me. I was very sure about this case.
This being the TRC cases.
Yes. Given my relationship with the victims of these cases, you know Mrs. Mxeng? She was killed on the 2nd of August, a week before. She was the main speaker at the funeral of Goniwe Ngcuka in Kredok. And later she was killed. And so this is something that I hold very dear. And it's something that I wanted to do. And her killers have never been found. Never been found. And those are things that I wanted to do.
And how would that position or that attitude, that sympathy have factored into any decision had you been appointed to be influenced not to proceed with cases?
Never. Never. You know, this thing about political interference, it would happen if you allow it. If you allow it as national director, then of course there will be. But at the end of the day, what I've been saying is the decision is yours and yours alone. And you tell people, no, this is not how this is going to work. I mean, I can give you a number of examples about a number of other cases where people have tried to persuade me not to take action. Sending lawyers, advocates, making
would those be
representations.
non-TRC related cases?
Yes. Yes. But I was able to rebuff all those attempts and say no. So it never happened during my time. If it had happened, I would have been able to say no, sorry, it's not going to happen.
Yes. And in paragraph 39, if we can just go back to the statement, you say that TRC cases presented particular evidential and operational challenges. They were decades old, relied heavily on witnesses whose memories had faded or were no longer available, and required intensive investigation in an environment where both investigative and prosecutorial resources were severely constrained. Evidence had also been destroyed in many cases. And then in paragraph 40, you say decisions that were taken at the time were not a function of political preference or external influence. They were driven by the need to ensure that prosecutions proceeded only where there was a reasonable prospect of success, where the evidential foundation could sustain a successful prosecution in accordance with prosecution policy and policy directives. The limited progress on certain TRC cases must therefore be understood within the broader context of the NPA's developmental stage, the competing demands on its scarce resources and the operational complexities inherent in prosecuting apartheid-era crimes decades after they occurred. Can you perhaps elaborate for the commissioners on those aspects?
But I thought I'd already referred, for example, to the Biko case, you see, which really speaks to this paragraph, because these were the challenges that we had. These were the shortcomings that we experienced.
Yes. Can we then deal, in paragraph 41, you round this off by saying, at no stage did I receive, tolerate, or act on any instructions designed to shield any individual, organization, or political actor from lawful prosecution. Do you confirm that again?
I do.
And the decisions that you say were taken were consistent with the NPA's constitutional mandate, informed by its prosecutorial policy, evidential sufficiency, institutional capacity, and the need to build a functional and credible NPA. You confirm that?
Yes, I do.
Can you just then round this aspect off, and you've briefly spoken about it, with what you state in paragraph 42? For years as an activist and practicing attorney, I acted for families of those murdered by apartheid police. That work was not peripheral to my professional life and my very being. As NDPP, I was at all times fully committed to ensure there was accountability for the grave human rights violations of the past.
Correct.
Lastly, under the heading, the response to the allegation that you did not approach the President, in paragraph 43, one deals with certain vermins that arise in the Kalata affidavit. Can you speak to that?
Yes, I mean, there's a letter that was written by Commissioner Diale to Anton. There's a letter that was written by Commissioner Diale, who was in charge of detectives, written to Anton Ackerman, suggesting that he or I should approach the President, for the President to decide who should investigate these cases. I stated that I found that to be nonsensical, because the President's determination was very clear. The cases were referred to my office, and therefore they were handled in my office. There was, commissioners, I mean, a challenge really that we had throughout the work of the Scorpions. There was a tension between the Scorpions and the police. There was a view held that the Scorpions were receiving better media attention, that they were getting better resources, and so those tensions were there. And yet in the final analysis, I was responsible for the prosecution of all cases, coming from the police, from the DSO, from everybody. And so it was in the interest of justice that I made sure that even the police, wherever they were successful in the work that they did. And so these challenges and these tensions would manifest themselves one way or the other. And it was important for me that I try to manage them. This was one of those, because the police here were refusing to give Anton, Mr. Ackerman, the investigators that he was requesting, and use this thing of saying, go to the President. There was no need to go to the President for that. The determination had been made, and it was very clear. And so they were just refusing to assist. You know. So, yeah.
Finally, it's a long time ago, and obviously one's not requiring absolute accuracy, but at the height of the time that you were there, what was the highest number of investigators you can recall you had available?
We probably had roughly about 300, between 300 and 350 investigators, about 55 lawyers, somewhere there, 50, 55, and about 30 or so analysts, and about 5 or so accountants. So that was the number.
And
there were very few.
Yes, can you give the Commission, I mean, that's an abstract number, but rooting it with what was happening on the ground, how thinly were those investigators spread, those 320?
Very thinly. You see, the difficulty that, well, it was not the difficulty. I mean, what we introduced were teams. We didn't have one single investigator investigating a case. People worked as teams. So you would therefore have a team that will have prosecutors, analysts, investigators, all working together in one particular project. And so it was very difficult just to take one person out of the team, because we had teams, people were working as teams. And everybody wanted all their cases to be investigated by the DSO, and it just was not possible. We didn't have the numbers to do that. It was very, very difficult to decide which cases to take and which cases not to take. All of them deserved the attention, but it was challenging.
Thank you, Advocate Ngcuka. Chair and members of the Commission, that is all that we wish to lead on. And we're in your hands whether you want to put questions now to Mr. Ngcuka or
Thank
wait.
you, Mr. Pana. Mr. Siminya, are there any questions to put? Oh, Mr. Vani, any questions of clarifications?
Chairperson, I think it's probably best that we do our questions all at the same time, both by way of clarification and
Yes.
cross-examination.
Thank you. Mr. Siminya?
We also defer to cross-examine after cross-examination by the Galata Group, Chair.
Thank you. Ms. Muroka, sorry about that. Ms. Muroka, I'm used to you sitting that side. So I did not see you seated on this side. You are seated on the wrong side.
The intention, Chair, was to confuse.
Yes, which has succeeded.
Yes, if I may, Chair. Mr. Ngcuka, can I take you to paragraph 20 of your affidavit?
Correct.
And whilst you put a finger to that paragraph, I want to also refer you to paragraph 40 of your affidavit.
Thank you.
And then read to you what the Constitution says about prosecutorial policy making,
Thank you.
and ask you for your understanding of what this means. The national, it is section 179, subsection 5. It reads as follows: the National Director of Public Prosecutions must determine, with the concurrence of the Cabinet Minister responsible for the administration of justice. And I want your understanding what is meant by with the concurrence of the Minister, of the Cabinet Minister, prosecution policy which must be observed in the prosecution process. Now, that section of the Constitution, read with paragraph 20 of what you have told the Commission, I just wanted to understand what was your understanding of what was supposed, what was your, what were your responsibilities having regard to what you say at 20 and what you say at 40, paragraph 40 of your affidavit.
Okay. You must also read the National Prosecuting Authority Act. I just can't remember which section now, which says the Minister of Justice has the final responsibility for prosecution policy. So what it therefore means is that in determining the policy, one has to work very closely with the Minister of Justice. So that was my interpretation of it, and that's how it worked, and it worked very well in practice.
It talks, the section talks about concurrence, and the dictionary meaning of concurrence, if I may, means in agreement.
Correct.
So I would assume the National Director of Public Prosecutions and the Minister must agree on policy.
That's correct.
And am I to understand that doesn't amount to interference if the Minister were to say, let's talk about this?
No. No.
Thank you.
In fact, to ensure that there is smooth functioning of the system, it's very important that you work very closely with the Minister.
Thank you, Ms. Muroka. Ms. Ranto?
So if I may, one last question.
Yes, Ms. Muroka.
There was a time in when we worked very closely together. So I can ask this question. The building that housed the NDPP, what was it called?
It's Victoria and it's Fijian building, Victoria and Professor Mkanga building, named after the two of them.
Thank you.
Ms. Ranto?
Good morning and thank you, Commissioners. I hope today, Commissioner, I got it right.
Yes.
Am I audible enough? Thank you, Commissioners. Good morning, Advocate Ngcuka. Mine is about just 2 questions relating to paragraph 43 of your affidavit.
Sure.
And then I just seek clarity as to whether my understanding is correct in terms of your version, that you are informing the Commission that the issue of De Beer's letter was more of lack of adherence to intergovernmental relations by state organs rather than anything else. Is that how
That's
I
correct.
And then another one, just the last one that I thought maybe it's left hanging, the issue of your last sentence where you said you then assigned, I think, Advocate Ramaite and Advocate Leonard McCarthy to resolve the issue. So we're just interested as to outcome. Is it what we understood, that you cannot tell the Commission as to whether such issue was ever resolved, or there was any meeting in that regard?
Yes,
the
I
two
mean,
officials?
sorry. Yes, I mean, the issue really has always been the availability of the investigators. And so Anton wanted the investigators and he went to the police, he couldn't get, and so he went to to the Scorpions, and there was a tiff to and fro between him and Jeff Letwaba. And I said, guys, deal with these issues. So far as I'm concerned, those issues were dealt with because I was never again informed after that there are challenges, that there are problems. At no stage did anybody come back to me and say, these are the problems that we are experiencing. So when I said the guys deal with these issues, and I was satisfied that the matter had been attended.
Thank you, Commissioners. Thanks.
Thank you, Ms. Ranto. Ms. Ntloko?
Yeah.
Yes.
My apologies, please. There's one last question that I've
Yes,
forgot
Ms.
to ask.
Boroka?
Mr. Ngcuka, at paragraph 82.2 of Mr. Kalata's affidavit, I'm sure you haven't seen it, I'm not sure if you have. Reference is made to the De Oliveira unit.
Yes.
Are you able to tell us anything about that unit? And if I may tell you why I'm asking the question, is because we've had evidence in this commission that it was absolutely successful, it was a wonderful unit. You talked to us about the difficulties that you encountered as the national director, and the comparison is being drawn that it succeeded where you didn't succeed.
Thank you. The De Oliveira unit, I inherited that unit. Is the unit that did the cases of De Kock, Volta Passon, and others. Indeed, they did a good work. They did very good work. And I then integrated them into the Scorpions. And they carried most of the work that they were doing there. They took it back into the Scorpions. It's the first time that I hear that we didn't succeed with our work. It's a matter of public record that the Scorpions and all the institutions that I ran during my time did very well. And so whoever says that probably is not speaking, telling the truth.
My apologies, can I be more specific with specific regard to the TRC cases?
No, they did not. They were not investigating the TRC cases. The De Oliveira unit did not. In fact, the reason why we took some of these cases from the Pretoria office was because they were not being attended to, which is why we brought them into my office, so that they could receive the attention they deserved. So no, they were not handling those cases. I mean, some of the cases which that unit were dealing with when I took them over will include the Helderberg. You remember the plane that crashed outside of Seychelles? They're doing the crash, the President Samora Machel plane crash, the disappearance of Rox Dlamini. They were handling all those sorts of cases. And they continue to do that, but unfortunately, we couldn't succeed with those investigations. But I inherited that unit, and I incorporated it into the Scorpions. There were good people who did a lot of good work.
Are you through, Ms. Moroka?
Through. Thank you, Chair.
Thank
My
you.
apologies.
Ms. Ngcuka?
Chair, my leader is here today.
Or Mr. Kwala?
Good morning, Commissioners. Chairperson, we do not have clarification questions at this stage.
Yes.
We would, however, reserve a right to do so after cross-examination if needs be.
Okay.
Thank you.
Am I missing anyone?
Chair, we don't have any questions as mentioned, but before I forget, Chair, may I be excused from the proceedings tomorrow? I have to sit with Advocate Anton Ackerman to prepare for the leading of his evidence
Yes.
for later this week. But my learned junior and the rest of my team will be present.
Okay. Thank you for alerting us to that.
As the Chair pleases.
Thank you. You are excused for tomorrow. Advocate Ngcuka, we thank you for having availed yourself to come and give evidence before this commission. It is greatly appreciated. As has been arranged this morning, you will be recalled to come and be cross-examined by Mr. Vani on behalf of the Kalaka Group. So we hope you will make yourself available for cross-examination. Otherwise, we thank you for having come to give evidence. You are excused as a witness.
Thank you. Thank you, Commissioner.
Mr. Semenya?
Chair, the next witness is going to present evidence virtually. For that reason, might I just ask for a stand down of 10 minutes to get the logistics in place?
We'll take a short adjournment. Mr. Seminya?
Thank you, Chair. The next witness is scheduled for tomorrow. We thought it would provoke no controversy to have the witness today, but it does. So might the witness stand over for tomorrow?
Yes. These proceedings are adjourned until tomorrow at 10 o'clock.
As the Commission pleases.